Good morning, everyone. My name is Mike Delaney, and I'm head of the recruitment sector here at VWV. Today's session, we're going to be looking at the latest decision on agency worker rights, and in particular, the right on the part of a temp worker to apply for a position where they are actually providing temp services in conjunction with an internal candidate, so whether they have the same rights. And I'll also be looking at the concept of mutuality of obligation, which has been the centerpiece of creating contractual relationships between hirers and individuals now for some decades. And that principle, again, appears to be under attack as a result of a few recent decisions, which I'm going to look at, and also followed on by Zara, who will be continuing her update on Ir35 and continuing with some of the themes that she highlighted back in our last webinar in January, and in particular the Hmrc's latest position now that the grace period has ended. Penny Bygrave then will follow and also provide details of data protection updates, again, which is going to affect all of you as businesses. But in the wider sphere of the recruitment market, the government is currently consulting on introducing a statutory code dealing with the principle of hiring and firing. And again, you need to be aware and watch out for that in the coming months. And also, as well, there's another government consultation out about creating supportive workspaces for the LGBT employees. So without further ado, let's touch on the first topic of agency worker rights. Next slide, please. Okay, next slide. So, as I'm sure you're all aware, the agency worker regulations introduced in 2010 provided for the same right for temp workers to receive the same pay and other basic terms and conditions equivalent to permanent staff after 12 weeks continuous service, as well as having access to facilities and also information about vacancies. In particular, in recent years, the rights of agency workers have increased further. All workers now have pay parity after 12 weeks, even if there are gaps in between assignments, the so-called abolition of the Swedish derogation, which occurred in March 2019. And also agency workers have the right to receive a key information document, again, introduced in March 2019, and also with effect from April 20, a right to receive full terms and conditions of engagement. But also as well, you'll see from the screen there that Regulation 13.1 of the Agency Worker Regulations 2010 also gave a temp worker the same opportunity as a comparable worker, which means a reference to someone who's already working at the establishment, a right to find permanent employment with the hirer. And also there was an obligation on the part of the hirer to inform an agency or a temp worker announcements about vacancies. Next slide. And against the background, there is Article 5 of the Temporary Agency Workers Directive 2008, which is the cornerstone and foundation of the Agency Worker Regs 2010. And that provided for non-discriminatory treatment of temp workers to enjoy basic working terms and conditions, as I just mentioned, particularly also in relation to working time, overtime, breaks, rest periods, and holiday pay. So the issue that's recently come before the court is whether or not Regulation 13.1 also entitled an agency worker to be considered for a role on the same terms as someone who's already employed in the organisation. Next slide, please. So I'm going to look now at the case of Coca and Angard Staffing Solutions Ltd. Angard Solutions Ltd are an employment business or temp agency, and they provided workers to the Royal Mail during periods where the Royal Mail had staff shortages. And Royal Mail from time to time advertised its permanent vacancies on a notice board and offered opportunities, firstly, to direct employees to apply for these roles. Agency workers were not eligible to apply for the role unless the vacancies were advertised externally. The issue was that Mr. Kocur felt aggrieved by the fact that he was a temp worker and was denied an opportunity to apply for permanent roles at Royal Mail. So he brought an employment tribunal claim on the basis that the hirer Royal Mail were in breach of Regulation 13 of the Agency Worker Regulations. And the employment tribunal agreed with his claim at first instance and held that the obligation to inform a temp worker about a vacancy also included the right on the part of the temp worker to actually apply for that role. The matter then progressed to the Employment Appeal Tribunal, who disagreed with the interpretation of Regulation 13.1 put on it by the Employment Tribunal. And the case then proceeded to the Court of Appeal, and their decision was announced in February. Next slide, please. So the Court of Appeal found that there was a need to balance the objectives between giving security of employment for the agency worker, as well as providing a degree of flexibility to workers and also hirers as well. And also they interpreted Regulation 13.1 in a very narrow way. And in particular, the only obligation on the part of Royal Mail as the hirer in this case was to provide information about vacancies. And there was no other obligation imposed upon Royal Mail in particular to offer interviews to temp workers. So in other words, what does that actually mean for the temp worker? Next slide, please. In my view, the decision of Coca essentially means that agency workers are not, in all respects, comparable with permanent workers as far as the right to apply for an internal position. But equally, I think hirers of agency workers going forward will welcome a decision that if they do hire temp workers and vacancies become available, their only obligation is to advise the temp worker of the right that that vacancy exists, but there is no right to actually offer that position or offer a temp worker to actually apply or be given an interview for that role. It's interesting as well that hirers now can, of course, give preference to internal candidates if vacancies arise over and above temp workers. And I think the other point to notice from this case as well, the court's analysis of the EU directive, which didn't seem to have any bearing on the fact that, of course, the UK has now left the European Union, so that didn't seem to weigh on the court's mind at all. So next slide, please. I want to talk about mutuality of obligation, which again, as I was saying earlier, is the cornerstone of creating contractual obligations between hirers and individuals, whether as employees, workers, or independent contractors. And I've set out on the slide there the fact that mutuality of obligation has always been considered to be a necessary element of an employee contract or indeed a worker contract, giving rise to obligations on the part of either parties to actually perform services. And essentially, that principle has been under attack as a result of some recent decisions, in particular the Uber case, which I'm sure many of you have read about in the press. There was no obligation on the part of the Uber drivers to perform work. The only obligation was if they did log on to the app, then of course there was an obligation to provide the service. But again, this issue of mutuality of obligation has come up again before the Court of Appeal in Nursery and Midwifery Council versus Sommerville. Next slide, please. Next slide, please. And what actually happened in Nursery and Midwifery Council in Sommerville was that you had an individual who was a member of the council's fitness to practice committee, but there was no obligation on the part of the Nursing and Midwifery Council to provide Sommerville with work to do, and there was no obligation on the part of Sommerville to actually sit as a committee member. Also, the fact was that Sommerville also undertook other activities outside being a member of the Nursery and Midwifery Council. And the issue arose as a result of the fact that the Nursing and Midwifery Council didn't provide Sommerville with any further work going forward. And the Midwifery Council, the matter went before an employment tribunal, contended that there was no obligation on the part of the council to provide Sommerville with any work, and therefore there was no contractual obligation, and as a result, Mr. Sommerville had essentially no rights. But again, the matter went to the Court of Appeal, and the Court of Appeal held that when an individual was performing work under a contract and providing services personally, there was no need to introduce a minimum obligation. And the fact was that once a contractual obligation was being performed, as and when, then that was sufficient to establish a contractual relationship between the Midwifery Council and Sommerville. So as a result, Sommerville proved their case that they were in fact a worker and entitled to the obligations that arose from holiday pay, etc. But this is going to contrast, I think, with what Zara is going to say about mutuality of obligation in the context of Ir35. Next slide, please. The case also as well didn't deal with the right of substitution, which can also again be a material factor when you're looking at relationships between hirers and workers. Next slide, please. And just finally, to finish off, Lord Hendy has produced a status of workers' bill, which is currently having a second reading in Parliament. And again, this might actually provide some clarity as to what ingredients, statutory ingredients, may have to be present going forward when creating either an employment relationship or indeed a worker relationship. Over to you, Zara.
Right, thank you, Michael. So as Michael mentioned, I'll be focusing on IR35 in my section of the webinar. Firstly, if you could just move on to the next slide, Amber, please. So firstly, I'll be focusing on just providing a short summary of the Ir35 regulations, followed by a brief update since our last webinar. And lastly, and most importantly, I will focus on a high-profile Ir35 related case, which provides some insight on the tribunal's approach to IR35. Now, I'll assess the impact the case has had on contractors who are providing their services through their personal services company. Now, we'll be answering any questions at the end of the webinar, but if we are unable to answer all the questions or if they require a more in-depth response, these can just be followed up by email. Now, moving on to the next slide, please, Amber. Right, so as a brief overview, the IR35 regulations are essentially concerned with the tax treatment of workers who provide their services via an intermediary like their personal services company. The purpose of the regulations are to ensure that individuals who ought to pay tax and national employee contributions as employees cannot, by the assumption of a corporate structure, reduce and defer the liabilities imposed on employees by the UK system of personal taxation. Now, in April 2021, last year, the Ir35 rules were extended to private sector organisations and not only the public sector. Now, the end user, rather than the contractor, is now responsible for undertaking a status determination statement, which is essentially the decision outlining if a contractor who is contracting via their PSC would be an employee of the end user if engaged directly by the end user. Now, the Hmrc CES tool, which is the Check Employment Status for Tax tool, is regularly used as an indicator of status to aid in making a status determination statement. If Ir35 applies and they are treated as employees, the fee payer would then be required to operate PAYE and national insurance contributions. Now, moving on to the next slide, please. And I thought it'd be useful to provide you all with a brief update since our last webinar. In that webinar, we focused on the overseas element of Ir35, where either a contractor or the end user is based outside of the UK, and whether this still attracts the Ir35 regulations. Now, since then, we've had quite a few clients who've made inquiries and needed clarification in terms of the Ir35 implications when based overseas, or if services were being provided overseas or in the UK. Our position and advice remains the same, but we've also received written confirmation from Hmrc that in a scenario where a worker is a non-UK resident who does not have any tax or national insurance liabilities in the UK and work is wholly completed outside of the UK, that would fall outside of Ir35. Now, an engagement can only fall within Chapter 10, Part 2 of Idta 2003, which is the regulation surrounding Ir35, if the worker has a UK liability to tax or national insurance contributions. So essentially, residency of the worker must be considered. Where a worker should be subject to UK tax and national insurance contributions based on existing domicile and residency rules, the UK domestic legislation applies to the engagement. Now, and so clients don't need to consider whether Ir35 applies, where there is no liability to tax and national insurance contributions in the UK. And as expected in those scenarios, the end client doesn't need to carry out a status determination statement as well. However, if some of the services were performed in the UK, this may change the outcome, as the end client needs to do the status determination statement in that scenario. And as expected, a worker carrying on duties in the UK for an end client will normally fall within the scope of the UK off-payroll working rules. There are some exceptions for non-UK residents visiting the UK briefly. Along with that, another important update I wanted to cover is essentially a warning regarding Hmrc's potentially tougher stance, as the grace period, which they had previously adopted after the new rules came into force on 6th of April 2021, has now ended. Now, before, in that grace period, Hmrc gave businesses this 12-month grace period to adjust to the new rules, where customers would not have to pay penalties for inaccuracies in the first 12 months relating to the off-payroll working rules, regardless of whether the inaccuracies are identified, unless there's evidence of deliberate non-compliance. Hmrc also committed that they would not use information acquired as a result of the changes to the off-payroll working rules to open a new compliance inquiry into returns for tax years before 2021 to 2022, unless there is a reason to suspect fraud. Now, as I said, this grace period has unfortunately come to an end yesterday on 6th of April. And so it's important to note that contractors should be extra cautious about any potential penalties they could face if they do not comply with Ir35. Contractors and end users should therefore not rely on only one or two of the Ir35 factors in isolation, such as control of or mutuality of obligation, personal service, which includes the right of substitution when making Ir35 determinations. The assessment should be made taking into account what is happening in practice and looking at all of the facts and circumstances of in that case. Right, so if you can move to the next slide, please, Amber. Thank you. Now, in this slide, I'm focusing on a high-profile case reported in the press in February this year. You may have all been aware of it, as it concerns the Radio 5 live presenter, Adrian Charles. Now, this case concerned Ir35 and whether it applied in respect of the ITV contracts and BBC contracts, and whether Hmrc could claim payments of over £1.7 million for income tax and national insurance contributions during the tax years 2012 to 2030 to 2016 and 17. Now, the first tier tribunal held that the hypothetical contracts between the BBC and ITV and the personal service company were contracts for services, indicating self-employment and not employment contracts, despite a degree of control and mutuality of obligation being established. So the off-payroll working rules did not apply in that case, and actually it worked out in the tax payer's favor. Now, just going into the facts of the case, Mr. Charles is a director of his personal services company, Basic Broadcasting Limited. He performed services for BBC and ITV through his personal services company. His hypothetical contracts with each of the TV companies were lengthy and represented over 75% of his income, although it only took up less than half of his working time. Now, the case considered the conditions when determining employment status, as established in the case of ready mixed concrete. So they considered mutuality of obligation, whether the contractor was under control of the company, and whether there was personal service existing in the scenario. And they also considered a holistic approach of whether the other provisions of the contract are consistent with the contract of employment. Now, in examining the relationship between Mr. Charles and the two TV companies, the tribunal found that there was mutuality of obligation, in that Mr. Charles was under some obligation to do work, and that the TV companies were under the obligation to pay for his work. The tribunal also found that Mr. Charles was under the TV company's control in terms of the way editorial control was exerted over the content he produced. Now, in that case, for instance, the director would control what images and sounds are being broadcasted, and the program editor would prepare the running order of the program. So Mr. Charles would essentially draft a script, would be sent a draft script in running order. He would rewrite the script in his own words, using his own unique style as a presenter. But then the redrafted script was reviewed, but only for accuracy and ensure it didn't clash with other planned sections that Mr. Charles might not have seen. So there was a degree of control exerted on Mr. Charles. Now, the case judgment also analyzes how a sufficient right of control in respect of what is to be done and where, when, and how it is to be done is an important requirement of an employment relationship, but by itself is not decisive. The key question in this case is not whether in practice the worker has actual day-to-day control over his own work, but whether there is to a sufficient degree a contractual right of control. The question whether control is sufficient takes into account the practical realities of the particular industry and considering those aspects of the performance of work that can be controlled in that industry. So it's evident that tribunals would take into account how the industry a contractor is in operates and what could be considered as control in that specific context. The tribunal also considered the criteria of personal service, and they referred to the case of ready mixed concrete, in which Judge McKenna stated that the servant must be obliged to provide his own work and skill. Freedom to do a job either by one's own hands or by another's is inconsistent with a contract of service, so a contract of employment, though a limited or occasional power of delegation may not be. So this also considers whether a contractor should have an unfettered right of substitution in order to demonstrate that the relationship is not of employment. Now, there's case law stating otherwise, but on the whole, a right of substitution does help your case when proving a relationship is not of employment. Now, despite mutuality of obligation and a framework of control being established, the tribunal found that because Mr. Charles was in business on his own account and had entered into the relevant contracts as part of that business, there was no employment relationship between him and the TV companies. So the first tier tribunals effectively concluded that its prima facie conclusion could be displaced, and as it had not been for his personal services company, Mr. Charles would have been in business on his own account. So accordingly, there was no relationship of employment. In reaching its decision, the tribunal took into account Mr. Charles' freelance work history, in particular that he used a management company to which he paid a 15% commission, and he had a personal assistant to promote his reputation and generally manage his career, which was indicative of sound business management. He also worked under the ITV and BBC contracts at the same time, so he was juggling both contracts. He provided his services to 25 additional clients, generating over £350,000 on the side. And he completed a wide range of work, including writing for several national newspapers, featuring in commercials, presenting roles, and completed unpaid activities to develop his own profile. Lastly, he used his own tools, so in particular his home office where he worked from, and he provided his services to the TV companies and was not integrated into their businesses, although he was an integral part of the programs he presented in. So as you can see, even though there was mutuality of obligation and control, because he was able to demonstrate that he had business on his own account, he was able to show that actually this pointed towards the fact that there was not a contract of employment in place. So moving on to the next slide, I just want to cover a few important implications of the outcome of this case. Now, one point is that if you are a contractor in business on your own account, like Mr. Charles was, it is imperative to demonstrate and evidence this. In a similar way to Mr. Charles, you should demonstrate how you have other ongoing business and are operating a wide range of work and a portfolio of clients to develop your own profile. This case shows that such practices could tip the scales in your favor. As a contractor, even if there are other factors in place which demonstrate employment relationship, like control and mutuality of obligation, the outcome could still be in your favor because you are able to show that you are in business on your own account. Now, another important point is to add that despite the outcome of this case, the judgment clearly demonstrates that the tribunals and judges place importance and take into account the factors highlighting employment status as determined in the case of ready mixed concrete. So they will still assess mutuality of obligation, control, personal service, and even if the individual is integrated into the organization. Now, it's evident that the outcome of this case was very fact dependent. And so contractors should be aware that although this was in favor of the taxpayer, each case will be different depending on the individual facts and circumstances. So you may have actually heard of a case called Little Piece of Paradise Limited versus Hmrc, where the outcome was in fact not in favor of the Sky Sports presenter in that case, who had to pay a tax bill of £280,000 in the end. Now, although this case was pre-April 2021, so before the new regulations came into force, this case still focused on the elements of control, mutuality of obligation, personal service. And in that case, it was decided that Mr. Clark, the Sky Sports presenter, was actually under the control of Sky. There was mutuality of obligation, although a substitute could be appointed. It was Sky who contracted directly with that substitute. So the tribunal in that case concluded that there was no right of substitution under Mr. Clark's own contractual relationship with Sky, and the off-payroll working rules applied in that case. So it's evident that there are differing outcomes. So it's important to be aware of this. And of course, as a contractor, you'd rather not be caught in such a situation, which is why I will cover in the next slide a few tips on what you should and shouldn't do as a contractor to avoid being caught under Ir35. Before I move on to the tips, it's important to just add that this case was the case of Basic Broadcasting Limited versus Hmrc was a first-tier tribunal case. So it doesn't set precedent, although I would imagine that it would have some bearing on future decisions. So going on to the next slide, please, Amber. So this is essentially a do's and don'ts summary, where I'll quickly summarize how to avoid being caught in such situations where you may attract IR35 as a personal service company. So firstly, ensure that the contracts are drafted to reflect the true nature of the working relationship between the worker and the client. So even though the contracts would be drafted in a certain way, it's important to still remember that Hmrc will look behind the contracts and see what's actually happening in practice. So even though if a right of substitution is included, that will be examined in practice to see if that actually is something a contractor can do. And also the worker should have control and should not be under the control of the end user, as this would indicate an employer-employee relationship. It's also very useful to use the CES tool, as this could be a helpful indicator, although along with the CES tool, it's helpful to seek legal advice, as it may not always be completely accurate. In terms of the do not list, firstly, workers should also not be under the supervision of the end user, as this would indicate an element of control. Having your own work pattern, your own uniform, tools would be good indicators of not being under such supervision. Now, there should also be no obligation to provide or accept work, as we have covered in terms of mutuality of obligation. And as Mike said, even though mutuality of obligation may not be considered in some cases, it's evident from the case that I covered today that mutuality of obligation was actually considered, and it did have a bearing in the outcome of the case, even though it was the business on his own account which was considered a stronger factor in the outcome of the case. Now, also, and lastly, as I said before, evidence everything in terms of if you are in business of your own account, make sure that you are able to demonstrate this, have practices in place where you're able to show that you are developing your own profile, you've got your own practices in place which show that you are practicing, you are in business on your own account. So essentially that's my do's and don'ts and my advice. So that's really it from me. But as I said in the beginning, if you do have any questions, we can address these in the end. And so now I believe I'll be passing on to Penny Bygrave.
Remember to unmute. Thank you, Zara. Thank you, Michael, for those a really interesting presentation. I'm going to be speaking now on some data protection hot topics. The next slide shows the agenda that we'll be following. We will be considering I will be considering some key recent developments, having a bit of a focus on cyber security and what that means in the current climate, and then some practical tips for how organisations can become data protection compliant. So on the next slide, we'll see the topics that we're going to cover in terms of recent developments, starting with international transfers. Now, international transfers is something that any regular attender to these seminars will know I've been banging on about for some time. For those of you that missed this, we left the European Union with Brexit, and we are no longer part of the European Union, which means that the European Union GDPR is no longer directly effective in the UK, although we do have some implemented legislation that preserves certain aspects of it. One of the last things to change from this move from being part of the EU GDPR to the UK GDPR is international transfer, and how we can do that securely. So brief recap, under both the UK GDPR and the EU GDPR, businesses are required to implement certain safeguards when transferring personal data outside the UK or EEA to countries that are deemed to they do not have an adequate level of data protection. Now, there's a list of countries which the EU has said do have protection, and the UK respects that list, but the main one that doesn't is the US, and it is the US that has caused the majority of the controversy in this area. So you may be familiar with the term standard contract clauses, or SCCs. These are what have been traditionally used to validate transfers within the European Union to countries outside the European Union. And after we left the EU and the EU regime, the UK ICO continued to respect transfers based on the EU rules, but then the EU rules changed, and we left in this limbo position where the EU had standard contract clauses that were not legally valid in the UK. Finally, last month, the UK adopted its new data transfer regime, and the ICO has issued a toolkit, but there are two documents that you need to be aware of. The first is the UK's International Data Transfer Agreement, or IDTA, and this is the UK equivalent of the standard contract clauses, or SCCs, which allow you businesses in the UK to transfer personal data to countries that do not have essentially equivalent privacy laws. You can use the IDTA as a standalone agreement to accompany an underlying agreement or master services or data processing agreement, and it places contractual obligations on the importers and the exporters of personal data, including obligations to take account of the European decisions in Schrems, which, again, listeners to this webinar, to these recruitment webinars, will have heard me discuss in the past. In addition to the IDTA, the ICO has also introduced a UK addendum to the European Union's standard contract clauses. And the addendum allows companies that are subject to both the UK data protection regime and the EU GDPR to secure international data transfers without executing a separate and independent agreement, such as the IDTA. The addendum is much shorter, it's a 9-page document, and it amends certain clauses of the EU contract clauses so that exporters of personal data can simply use the EU standard contract clauses plus the UK addendum. Now, a natural question for many businesses is whether they should use the full IDTA, International Data Transfer Agreement, or the addendum. The EU Commission has not made any comments on the UK IDTA or addendum, and because the businesses that operate within the UK businesses that operate within the EU need to comply with both the UK GDPR and the EU GDPR, it seems to me that the addendum makes sense for those businesses, because then we're looking at using a document that has been designed for compliance with both regimes. For those businesses that are already contracting on the European SCCs or the old form UK SCCs, they have until March 2024 to introduce the new arrangements. And this is similar to the EU's grace period historically, about moving from the old SCCs to the new ones. In addition, it's worth bearing in mind that in March, so that in 2025, we'll be having a review of the UK adequacy decision. And so if you had hoped everything was going to go quiet in this area now. It is possible that there are further changes to watch, but at the moment, for now, we have the answer to international transfers. Now, just to be aware, it is not enough just to use the contracts, sign them, put them in the drawer and forget about them. You must also do the transfer risk assessments to look at the adequacy and what protection and what, if any, supplementary measures need to be taken that's specific to the destination country, the importing country. And that's the same whether you're using the EU clauses plus the addendum or the Idta. International transfers can be incredibly technical, and with so many businesses operating globally and so many regimes, excuse me, to consider, you know, it is really worth mapping and classifying your data transfers and really getting to grips with where your data is going. The next development, sort of moving on from there, because marketing is on this slide, is marketing compliance. This has been a hot topic for the ICO for some time, and it is where a lot of our recent fines have come into play. Now, we are seeing fines in 6 figures regularly for marketing non-compliance. So this is unsolicited electronic marketing, contacting people who have not opted in, who have not positively agreed to receive marketing from you. It's even relatively low level incidents are seeing fines in the tens of thousands, but we are seeing, you know, the latest one, you know, £200,000 fine for a home improvement firm for sending nuisance emails. There's always mitigating factors. You know, did you take reasonable steps to check that people had opted in, and aggravating factors that you actually, you know, deliberately, knowingly contacted people who you knew had not asked to receive marketing from you. But this is an area that the ICO is very keen on, and it links quite closely with another area that's under the microscope at the moment, which is cookies and cookie notices. The law hasn't changed here, but some campaign groups that are pushing for data protection compliance are encouraging people to make claims against companies who are not providing the appropriate cookie notices. So if you find yourself on the receiving end of one of these complaints and claims for financial damages, it's quite tricky. You need to make sure that your cookie banners and your cookie notices are compliant with the current law, and the current law is still under review. But anyone who's working online will be seeing this whenever you go on the website. You're being bombarded with cookie notices. These are organisations that are trying to comply, and it does look as if the standard is that you must provide granular opt-in consent to cookies. That has always been the case, but the way organisations have provided the notices in the past have come under scrutiny recently and just been held not to be enough. So if you use cookies on your website, have a look at your notices, have a look at what you're doing to allow browsers to opt in. They must opt in to anything other than the strictly necessary cookies. Another recent development is the data subject rights, just general awareness. We are seeing far more sophisticated requests for access to data, and the right to erasure or the right to be forgotten, you need to have a policy in place to deal with these requests when they come in. They are time sensitive. If you, miss the deadline, you could, that is an aggravating factor as far as the ICO are concerned. People are sending these requests sometimes for irritation purposes. Unfortunately, the rights, data subject rights, are purpose blind. So unless it's manifestly excessive, you have to comply. So you need to make sure that you've got a procedure in place internally for what's going to happen when you receive one of these requests, because it is a when rather than an if. Which takes me on to the next bullet on this slide, which is the Information Commissioner's increased focus on accountability. Now, accountability is one of the core data protection principles introduced by the GDPR. It makes you responsible for complying with the law. It's not enough just to comply, you must demonstrate that you comply. So you must put in place appropriate technical and organisational measures to meet the requirements of GDPR, and then you have to be able to show that you have done so. There's a number of measures that you can take, adopting appropriate policies, taking a data protection by design and default approach to all introduction of new technology, putting written contracts in place with organisations that process personal data on your behalf. This is not new. This was always there, but now you have to prove it. Maintaining documentation, implementing appropriate security measures, reporting, having a process to report personal data breaches, even if you've never actually had one, carrying out data protection impact assessments. Accountability obligations are ongoing. So if you've put in place compliance measures in 2018, they need to be reviewed and they need to be updated. The ICO has a good checklist for this, for how to comply. The final point on recent developments is the government's proposals for further data protection reform. Last September, we saw the introduction of the government consultation, Data a New Direction, which was received with mixed reviews. It is certainly the intention of this government to try and get rid of some red tape. They have sort of come into a bit of conflict with the ICO over who's going to monitor and regulate that. I'm expecting to see some further reforms on data protection announced in the Queen's speech in 2025. But as I mentioned earlier, at the moment we have an adequacy decision from the EU that they have deemed the UK as having adequate security for personal data. If we move too far from that regime, we might risk losing that adequacy decision, because the sunset clause, as I mentioned earlier, is till 2025, then our adequacy decision comes under review. So those are the recent developments. I'm just looking forward. I say it's not a settled area. There will be some further reform later this year, so watch this space. The other thing that I wanted to touch on the next slide, just to say that this is the biggest issue for most organisations at the moment: cybersecurity. It is not if, but when you are going to have a data breach, and you are obliged under GDPR to have appropriate technical and organisational measures in place to protect personal data, to protect against data breaches. Now, many of the data breaches that we're seeing are third-party hackers, and some are so sophisticated that really no organisation could protect against them. So the main thing, as obviously you don't leave your systems unprotected, but the main thing is to be looking at how you will respond, what mitigation steps that you will take when you are hacked. The readers of our e-zine will have noted that even solicitors sometimes get it wrong, and a firm solicitors recently fined, not so much for the breach itself, but for the fact that they hadn't taken steps to minimise it, to mitigate it, and that they didn't have an appropriate response in place. You must have a data breach, a procedure to anticipate data breach, that you understand what will happen when it happens, what you will do internally, what you will do externally, including notifying the Information Commissioner's Office. Data breach reporting is compulsory. If you fail to report a data breach, you are at risk of a fine. The one thing I would say is always check with your insurers before reporting, but otherwise err on the side of reporting, even if you think there is no serious harm, rather than the risk of getting it wrong, of the ICO thinking that there is serious harm and fining you for failure to report. Very short reporting times, 72 hours. You can do a brief report to start with and then follow on, but do have that policy in place. Do be ready in advance. On the next slide, we'll see that the National Cybersecurity Centre has called for increased vigilance. In particular, they are saying that ransomware is the biggest cyber threat, and they have issued guidance, as have the ICO. So I'm not going to go through that in any detail now as to how to avoid it. With your risk with your people, with your staff, phishing emails, and we get phishing emails every week, every day. I think we get a notification of malicious emails, and as I said, you must have be ready for this and take appropriate measures such as patching, access controls, and threat detection. So on the next slide, some practical tips. Accountability, as I say, this is a really big thing the ICO are pushing on. So first of all, think, what are our policies? Do we have appropriate policies? As an absolute minimum, you need to have privacy notices, external facing, published on your website. This tells the world what data you collect about them and how you protect it. Then an internal data protection policy that tells your staff what is expected of them, procedures for how to deal with the subject access request, procedures for reporting data breaches internally, escalating them. And then I cannot emphasize strongly enough just getting into the habit of doing a data protection impact assessment whenever you introduce a new process or procedure. If it's if it's online, if it's technical, then it's compulsory. If it's not online, what processes do we do that are not online these days? But if you're collecting personal data and are not online, then it's whether or not there will be the test is whether or not there will be a serious impact. I would on the side of, if you're collecting personal data about individuals for any new process, for any new program that you're planning to launch, it is likely to have a serious implications for individuals' privacy. So always do a DPIA. And then your ROPA, your record of processing activities. also known as Article 30 records or accountability records. This is your internal document. This is the first thing that the ICO is going to ask you for if you do have a data breach, or if you do end up under their microscope. This is the #1 accountability record. It shows that you've done some data mapping. It shows this document or series of documents, should be able to demonstrate that you take accountability for data protection compliance seriously. Staff training, it's not enough to have the policies. You need to train your staff. It needs to be practical. It needs to include a test. And if you've got specific groups with specialist areas of expertise, then they should have some bespoke protection, bespoke training, which will take me to my next slide, a blatant bit of promotion here. But we offer, VWV offers a data protection e-learning course that's targeted at SMEs. It's an online course that your staff can do. You have a record as to who's completed it. You are able to evidence that you've carried out appropriate staff training. There are different levels. There's a basic introduction to data protection. It covers sharing personal data, and it covers subject access requests and the rights of individuals. On the next slide, we have a poll that you can indicate if you are interested in any e-learning support, and then somebody will contact you. And I'm conscious that I've left very, very little time for questions. I hadn't realised quite how long I was going to speak for. And so moving on. So first of all, we'll do the poll, and then we'll, if you have any questions, we'll deal with those.
Yeah, there are a couple of questions in the chat box, which I'll deal with very quickly as we're running out of time. The first one: is it discriminatory not to offer a temp worker the right to apply for a permanent position where there are internal candidates? And the answer to that, I would say no. The case that I've talked about, Coca, makes it clear that the only obligation on the part of a hirer is to provide information and nothing further. Second question: what if there are no internal candidates? I would say in that particular case, the normal rules relating to the hiring of staff, whether they're temps or otherwise, apply in terms of advertising for the vacancy and also selecting in a fair and non-discriminatory way. Another one as well, I think it's for you, Penny, where are agencies allowed to send unsolicited CVs to hirers with whom they previously dealt with in the past? Is that a data breach?
So if you're sort of saying it's unsolicited between the agency sending to the potential clients, then what the issue is, have you told the candidate that you will send the CV to that agency? So unsolicited marketing is about sending emails to individuals. It's not about sending emails to corporates. So in this case, you will be relying on legitimate interests of the agency's organisation, the agency's business, to share that information with a potential client. But you need to look at your privacy notice to say, have you told candidates that that's what you're going to do? Now, if I'm a candidate and I've given my CV to an agency in order for them to find a job for me, I am not going to be surprised when the agency shares the CV with potential clients. So that's not unsolicited marketing. However, you need to be sure that you have given the candidate the privacy notice to explain to them that you're going to share their CV with third parties. Legitimate interest, or potentially it could be it's necessary for the contract.
I think we've got time for one final one. I think it's for you, Zara. If the concept of mutuality of obligation is now obsolete with a view to establishing worker status, is it still relevant to determining employment status and contractor status?
Okay, that's a good question. So from actually the case that I discussed, it's evident that they still do consider mutuality of obligation as a factor for employment status. So it seems that it is still considered. So I would say, even though it's obsolete in other cases, in this case, it demonstrates that tribunals would still consider mutuality of obligation. So yes.